So I'd highlight two things. First, choose your investors carefully. I would say that one of the pointers towards a company that is likely to demonstrate success over the long term and ultimately achieve a successful exit is the nature of the relationship with the investors and the partnership with the investors. And that is not only between the founder or management team on the one hand and the investor on the other, it's also between the investors that make up the supporters or the investors of the company. So the dynamic between the management team and the investors and the dynamic amongst the investor group itself is critical, and therefore the investors that you take on board, money is great, but don't just rush towards the money that's available. The second thing that I would highlight in a slightly more technical point is the importance of hammering out in the term sheet the key commercial and legal points of the deal at the beginning of the process. It can be tempting when you have an offer of investment to keep the term sheet short, to move into the legal process and to get the deal done. Whilst that's important, actually as a founder team, you are at your strongest from a negotiating point of view at the term sheet stage, when you may have other discussions with investors ongoing before the deal is done and you're still being courted by the investors. So hesitate at the term sheet stage, get things out in the open and agreed, and then move into the legal process. How important is it to get a good shareholders agreement in place early on? I'd say 2 points to that. First, initially at least, is often not that important, and it can be a waste of money to instruct lawyers to put a shareholders agreement in place, for example, amongst a founder team in that relatively short period pre-fundraising. So point one, perhaps not necessarily think about that carefully. The second point I'd make is when you take on your investment, and you will have a shareholders agreement because your investor will ask for one, hopefully it is never that important because the nature of your relationship is such that you're not turning to look at a shareholders agreement. However, even if you never look at the shareholders agreement, the fact of its contents can inform the dynamic of the relationship between you and your investor. And therefore, as a founder team, it is worth thinking early on what the key aspects of that dynamic are and how provisions of the shareholders agreement will allow you to shape that dynamic in a way that is positive for you. To get it more specific, think about control of the board. Should you as a founder team, notwithstanding there'll be an investor director or two, maintain ultimate decision-making authority at board level? Think also about the veto rights. The investors like veto rights. Is it appropriate that you as a founder team also have some form of veto rights over key decisions that relate to the business of the company? So hopefully not important, but even if it's sitting there in a drawer, in fact, if you're in a good position in your shareholders agreement, that can be helpful in terms of your relationship with your investors. So the difference between taking money from angels on the one hand and VCs on the other, the difference, in my experience, is largely driven by the relatively obvious fact that if you're an angel, it's your own money, and if you're a VC, ultimately it's someone else's money. And the upside of that, certainly for younger companies, is the flexibility and speed with which angels can move. If you need your first few £100,000, I finance and you need it quickly, then not only are there more angels around willing to lend that sort of money than there are VCs, but the angels may be willing to take a far more flexible approach on protections in the documentation than any VC possibly can, because they're responsible for managing someone else's money ultimately. So the difference between vesting and reverse vesting on the one hand and the EMI schemes on the other is really the difference between the lever provisions that will apply to you as a founder, that's vesting and reverse vesting on the one hand, and the scheme rules or lever and other provisions that will apply to the equity or options that you give to employees who join the company after the founders on the other hand. So dealing with vesting or reverse vesting for founders first, the key concept here is reverse vesting rather than vesting. The reason for that is that as a founder, you will have your equity on day one before the investor arrives. So given that the investor is ultimately investing in you as a founder or founder team, the investor will want to be sure that were you to disappear off the day after his investment or a year later, that that there is some form of recourse against your equity. And the way that that works, because you already have your shares, is reverse vesting applies a reducing over time percentage clawback on your shareholding. Typically, this percentage is somewhere between 50 and 100% to reflect the amount of effort that you've already put into the company before the investor arrives. And that reverse vesting period from which it reduces from that 50 to 150% down to 0% is typically 3 or 4 years. It may appear a little bit off-putting when you see this in the term sheets from the investor, but understand that the investor is ultimately investing in you, not the concept in many ways, or the intellectual property, but is you as a founder team, and wants to be sure that you're going to be there for the duration. EMI options are a government-approved and therefore tax-efficient option scheme for employees of the company. And they will contain vesting provisions that work in a very similar way to the reverse vesting provision for founders. And they'll also deal with other restrictions and limitations and rights of option holders. The key point I'd make there, as if you're thinking with your founder hat on, is that it can be a very good idea to limit exercise of these EMI options, these right to buy shares, to limit the exercise of that until an exit event. And the reason for that is to avoid a large number of employees and perhaps indeed ex-employees becoming shareholders of your company before you've actually got to the exit. If you're lucky enough to be in the position of receiving term sheets from VCs, you're at that stage, and the term sheet will no doubt come with a much greater degree of complexity than the sort of term sheet that you may have been getting from your angel investment rounds, then I would say 2 things. First, do speak to a law firm that understands this market and understands in particular what market standard terms are for these various provisions. You may or may not be familiar with the terms that are in this term sheet, but by speaking to a lawyer who is doing X number of these transactions a year, you will get a very useful perspective on what's being presented to you and where you might push back. Second, if it's at all possible, procure another term sheet from an investor, because there is no better position to be in when having a discussion with what might be your favoured investor than being able to cross-refer to one or more other offers at some degree of certainty that are on the table from other investors. And that can be helpful both in terms of comparing the terms, but also in terms of creating the right conversation or dynamic between you and the investor. The one piece of advice I would give, and I think this helps frame or colour your decision-making through this important stage for your business, is what does your company look like in 5 years' time if it's been a huge success? If you've built $1 billion business, what does your investor base look like from angel through to institution? What does your founder team look like? What does your intellectual property look like? What does the structure and dynamic and culture of the company as a whole look like? And if you envisage that, and that picture of your successful business in 5 years' time, then that will, I believe, help you on your journey through these early stages.